it is always fascinating when you get a 9-0 court decision. Now, there were actually 2 cases before the court dealing with the Electoral College and this notion of faithless electors. The case that is most noteworthy, I suppose, is Chiafalo v. Washington, and there's a related case of Colorado Department of State v. Baca. And the important thing to note about these cases is that they were separated, but their decisions are basically the same, as I understand it, where the Supreme Court ruled that you cannot have a faithless elector. If you, as an individual, decide to vote against the law of your state for some other candidate that did not win the popular vote of your state, like Washington and Colorado, then you can be penalized by the state for doing so, as it happened in both of these instances. The Supreme Court unanimously ruled in favor of the idea that these states do have such authority. And I wanted to talk about it, dive into this landmark decision with Professor of Law at the Sturm College of Law at the University of Denver. Professor Robert Hardaway is joining us now. He was actually involved in putting forward what's called an amicus brief, or a friend of the court brief in these cases, and that had actually been cited during oral arguments.
Approximately 32 states, including Colorado, have rules, laws regulating their electors, and indicating that the electors are required to reflect the will of the people in that state. Now, the Constitution, under Article 2, does not say anything about whether electors have free will or whether they. The only thing the Article 2 says is that the legislatures of each state can determine and regulate electors. And it was this basic constitutional provision that the Supreme Court relied upon in saying that states have the power under Article 2 to determine how electors are to be regulated. And that's why they upheld Colorado's law, which regulated electors and provided the requirements for the office of elector. The main requirement is that they vote for, in the Electoral College, the person whom they promised under oath to vote for. And that was the basic principle that the Supreme Court relied upon in their 9-0 opinion, saying that states had the power to provide such laws. Now, other states do not have such laws, and in those states, electors would still be free to vote for anyone they want to. But in the 32 states that, like Colorado, have a law requiring electors to vote for the person to whom they're pledged to vote for, those laws have now been upheld. And this is, I think, a very good result, because we saw in the last election that there was a great deal of threats and intimidation against electors, trying to get them to violate their pledges. And that would mean that we really have two-stage election, one in November and then a second one in December, where all bets are off. And if people are threatened or their fines are offered to be paid, an election could be changed simply on the whim of an individual elector. And back in the year 2000, the election was won by exactly 2 electoral votes. All you'd have to do is change the votes of 2 electors by offering to pay their fines, as was done in the 2016 election, and you could change the entire outcome. So I think this is a very positive result, and that's why I think it was 9-0 in favor of the ruling of the court.
Professor Robert Hardaway, again, of the School of Law at the University of Denver. Good to have you once again on the program. I want to ask you, please, about the notion of the national popular vote. We were talking about this in the previous segment. Please speak to this issue of a stalking horse of sorts that has been claimed, that this is a stalking horse for the National Popular Vote Compact to try and bring that about.
Yes, well, the NPVIC people don't make any bones about it. They say, we really just want to abolish the Electoral College. They have some threshold problems, though. The whole idea of the NPVIC is that some states would form a kind of a cabal, and they would agree to ignore the will of the people in their state and instead cast their electoral votes. The state of Colorado, for example, would cast their votes in accordance with the popular vote in the rest of the states. The problem with that is there is no popular vote. It's based on an illusion that when voters go into the voting booth, they are voting for a presidential candidate. Of course, they are not voting for a presidential candidate. They're voting for an elector. And if that elector then goes on and votes for someone other than the person they're pledged to, how would you count the popular votes, for example, for Hillary, if the voters in Colorado voted for a slate of Democratic electors who had pledged to vote for Hillary, but then they vote for the Republican instead, which is exactly what happened in 2016? There's no way to count popular votes because there are no popular votes for candidates. There are only popular votes for electors. This is the way it works in Great Britain and all the great parliamentary democracies. You vote for in England, they don't call it an electoral college, they call it a parliament. You vote for a member of parliament, and then that member of parliament then goes to the parliament and casts the vote for the leader. But this scheme this is about the 700th scheme in the last 200 years that has been proposed. But every time this scheme similar schemes have been proposed, they always get shot down by what John F. Kennedy said when he resisted attempts to mess with the Electoral College back in 1956. And what he said at that time was, and he convinced the people not to mess with it. He convinced his fellow senators. He said popular vote election would greatly increase the likelihood of a minority president, that is, a president who received a minority of votes. It would break down the federal system under which the states enter the Union, which provides a system of checks and balances that ensure that no area or group shall obtain too much power. Now, the reason the drafters of the Constitution provided for a separate electoral college was because they wanted to adopt certain elements of the British parliamentary system, which is that you vote for members of parliament, we call them electors, and that they vote for the leader. But they didn't want the same body, the Congress, to be the same body, the elected president, because they wanted a check and balance. They didn't want a president to be beholden to the legislature. And that's why they provided for a separate electoral college. It's really sort of a different branch of Congress, but it only has one duty, the duty to elect a president.
Now, how do you think this decision of the Supreme Court in both the cases of Colorado Department of State v. Baca and Chiafalo v. Washington could impact the national popular vote? Could they?
I think it could. I mean, for one thing, it highlights that there is no such thing as a popular vote. For example, how would Colorado decide how to count popular votes for Hillary when the Hillary elector decided to vote for the Republican? Do they count that as popular votes for Hillary, or do they count that as popular votes for Trump or another Republican? There's just no way to calculate it, and the media fosters this illusion. At the bottom of the screen, when you look on election night, it says the popular votes for Trump or Hillary are as follows. Those are not popular votes at all. And in some states, for example, in Alabama, they have been known to present voters with a slate of unpledged electors who have not pledged to vote for any candidate. Now, if the Alabama voters vote for, say, the Democratic slate of unpledged electors, how do you calculate the number of popular votes to be allocated to a particular presidential candidate? Simply can't be done. And when you present this issue to the MPVIC supporters, they say, well, I don't know how that would be resolved. I guess you just have to disenfranchise all the people who voted for electors that didn't vote for the person that they're pledged to. So disenfranchisement is of hundreds of thousands of voters. And the Baca attempted to basically disenfranchise 138,000 Colorado voters by saying, even though I told my voters that I promised to vote for Hillary, I'm going to vote for a Republican instead. Now, how do you count popular votes in that situation? You can't.
Sure.
So it's a non-starter from the beginning. Of course, there's all kinds of constitutional issues involved with that, but that's just a threshold issue. The MPVI says we'll count as popular votes that are associated with the vote of an elector. But do you count the popular votes for an elector who had pledged to vote for Hillary? Do you count that as popular votes for Hillary, or do you count it as popular votes for the Republican? There's no way to do it. And the newspapers are the ones that count up these popular votes. And delegating to the newspapers, such as Fox News or whatever, the duty of trying to figure that one out is really beyond the pale.